Hi, this is Tommy Pope. I'm an attorney with Elrod Pope Law Firm, and we're glad you could join us here tonight. We're excited for the town hall meeting that we can bring you in your homes. We also look forward to future town hall meetings. We had a good attendance last town hall meeting, and we look forward to future ones coming to your community in the coming weeks. A little bit about our firm. We're based here in Rock Hill. I've been here my whole life, and they pick at me for saying it now, but what we're dealing with is not your daddy's Bow Waters. It's not the company that we grew up with, occasionally having a smell. There's some serious issues, and so I was excited when we were contacted by this group of attorneys of the possibility of collaborating with Elrod Pope to tackle this problem that's right here in our backyard. Because what we want ultimately is things to be fixed. We want remediation. We want the company to be good corporate citizens. We're not trying to run anybody out of the community, but we also don't want to run our citizens out of the community. We don't want to run the folks that have chosen to live here out of the community. So I want to show you a little bit and introduce a little bit about our team. The format we'll have tonight, we'll go through a brief presentation and then we'll just open it up for questions, because I think the biggest thing we could do is touch on the questions that are important enough for you guys to spend your time with us. So if I could have the next slide, please. If you'd hit one more, please, sir. As I indicated, what really drew me in with this group, it started with Leon Stavrinakis down in Charleston. Leon and I serve in the State House together, and he'd done some work with Phil and Chase previously, and I was fortunate enough through Leon to do some work with them also. And again, I think what brings me to, you'll hear me say this numerous times, is the team. You know, oftentimes when we see the commercials about class actions and lawyers, wanting you to call in and join, and it's really about the lawyers. It's not about fixing the problem. But I think you'll quickly see, if I could show the next slide, that this isn't really a group of just lawyers coming to town to see what they can take away from York County and Lancaster County in North Carolina. It's a team that's here to fix a problem. And these folks have proven themselves over and over. Again, I have no concerns about having my name or my law firm's name associated with the work these folks are doing. And I firmly believe when this is over, we'll have a resolution that makes it better for our community. With that being said, we're going to go forward quickly now, again, because we want to be respectful of your time. I want to start by introducing Phil Federico. He picked on me last time that I didn't introduce him properly, and I don't think I can do him justice. Let me just say that I'm honored to have Phil, to have Chad, to have these guys on our team, and I look forward to working with us. Phil, I'll hand it over to you.
Thank you, Tommy. Folks, it's nice to be with you all this evening. And I have worked with Tommy and Leon before, and they're fine attorneys. And if we could go to the next slide. This is the hardest slide for me because I have to talk about myself. So I'll be quick. I've been a trial lawyer now for 37 years, and for about the last 10 years focused on mass torts and environmental cases. And the most recent case I handled with Chase Brockstedt in Delaware is called the Mount Air case. And it involved a chicken processing plant that was putting out high levels of hydrogen sulfide into the air, causing health problems in the community. And back this past April, we got that case settled for $205 million. I would also point out that I am currently working on other cases in South Carolina. I just spent 10 days in South Carolina. I actually have a home in South Carolina. And I represent the Charleston County Airport Authority, what's called the Environmental AFFF. That's the firefighter foam case. And I also represent a number of counties and cities in the opioid litigation. And I'm lead counsel for over a dozen school boards in the Juul litigation, both of which are mass torts. If we could go to the next slide. And I want to go over a timeline with you all. And this timeline speaks to really why we are where we are at this point. Back in December of 2018, you can see that New-Indy was purchased this paper mill, which has been in the community for a long time and had not previously really caused any problems or danger to the community. New-Indy wanted to convert the mill from white paper to brown paper for containerboard, and therein lies the problem. Throughout their conversion by November of 2020, they had completed the conversion, had increased production, and they were putting out exceedingly high levels of toxic air pollutants and overwhelming odors, specifically hydrogen sulfide, which causes adverse health effects, and you'll hear more about that later. And then in April of 2021, New-Indy, instead of, when being asked about these problems, and there were many complaints being made, instead of taking ownership of the problem and focusing on fixing the problem, they denied having any responsibility and asked DHEC if they could increase production. If we go to the next slide, you'll see a month later, in May, DHEC responded and did a nice job. Congratulations to them. And they indicated to New-Indy that the odor that was coming was injurious to the welfare and quality of life and is interfering with the use and enjoyment of property. And we know how bad this odor is because it actually permeates houses where the windows are closed and doors are closed. Later that month, the EPA jumped in and issued an emergency order, which is exceedingly rare. Only in the worst cases do they do this, under the Clean Air Act, ordering New-Indy to take remedial action. We know from our experience in the Mount Air case and other environmental cases that while these public agencies try to do their best to control corporations and fix problems, frankly, there's only so much they can do, and they typically fall short. So we jumped in here in June and we had been investigating the case for 3 or 4 months when it came up on our radar. And then in June, we filed our class action here in the Rock Hill. If we could go to the next slide. And you can see, and this is an interesting slide, we need to update this, and we're about to get fresh information. But as of May 7th, there were over 17,000 odor complaints made to DHEC. And this is somebody actually getting on the computer, filling out a form, and making a formal complaint. That's 2 months ago. And we've been hearing from callers in the past day or two that they are still experiencing odors, and some worse than ever. So we know this number in the last 60 days has to have gone up substantially, and the problem is far from over. If we could go to the next slide. So we're going to discuss with you this evening how this environmental disaster happened. And in an effort to do that, we bring in the real experts, and we have a group of them that will present to you tonight. If we could go to the next slide. And I want to talk a little bit about our first expert, and that is an environmental law consultant, Roger Truitt, who started his career, frankly, as an environmental engineer, and decided to go to law school and became an attorney, and has devoted his professional career to the practice of environmental law. And it says here for the defense. That's the other side. And he's an invaluable asset to be on our side in this case and other cases, because he really knows what the other side's thinking and where we need to go to be successful and how to get there. Roger worked for 21 years as a partner at DLA Piper, one of the largest law firms in the world, and handled dozens of air and groundwater contamination cases. And as I say, he worked with us most recently in the Mount Air case, where he investigated and helped us solve many of the same problems you all are experiencing with New-Indy. If we could go to the next slide. And really, it gives me great pleasure to introduce Roger Truitt. And Roger, I'm going to turn it over to you. And Roger, I hope you're there.
I am here. Thank you. Thank you, Phil. I have to say, first of all, that although I represented large corporations with some very serious environmental issues, I never saw a case like this where we had such noxious and toxic air pollutants affecting such a large area. So in this case, I'm very happy to be on the side of the people. I'm going to talk a little bit about the wastewater issues and the wastewater contamination, because that's where a lot of the odors originate. Can we have the next slide? First of all, we dug into, this is from EPA's website, to look at New-Indy's wastewater record over the last year. And you can see for 3/4 of last year, they were in violation. In fact, the first quarter, actually the second calendar quarter of last year, they failed to submit the discharge monitoring report, and then were in violation for other purposes. Can we have the next slide? So what have we learned so far? First of all, the New-Indy plant is permitted to discharge up to 25 million gallons of wastewater per day to the Catawba River. And that's a big number. To kind of get your mind around it, if you filled up Bank of America Stadium, where the Panthers play up in Charlotte, with 30 feet of water, that would be 25 million gallons. And they discharge that every day. That's over 17,000 gallons per minute. So it's a huge amount of wastewater that they are trying to treat and ultimately discharge. Now, the permit that they have was issued 12 years ago by DHEC, and therefore we believe it's outdated. It's been up for renewal for 7 years, so it's overdue for renewal as well, and doesn't reflect what's needed for this new process that New-Indy is, a new pulp and paper making process that New-Indy is engaged in. DHEC did a wastewater inspection this past March, and they found multiple violations. There's a report posted on the website, DHEC's website, including the fact that New-Indy had no current odor abatement plan. Well, hello, that's why we have such terrible odors leaving the plant or the mill and going out into the community. They also noted that there had been changes to the treatment process without getting DHEC's advance approval, as they're required to do, and saw foam leaving the site. And we'll talk about that in a second. There's been some recent sampling in the Catawba River by DHEC, and our wastewater expert, who I'll introduce in a minute, has indicated to us that it represents a significant increase in dissolved solids and phosphorus downstream of the New-Indy discharge. Well, because the permit is out of date, those contaminants are not even regulated under the permit. Next slide. And here's where you may have seen in the media about the Catawba River Keeper, which is a nonprofit organization that is, its mission is to preserve and protect the Catawba River. They have been very concerned about the reports of foam that are in the river downstream of the New-Indy plant. And you just see some photos here that have appeared on TV or in the other news media. Next slide, please. So I mentioned a wastewater expert that has been working with us. It's Ken Norcross. By the way, this is the first of many what I call dirty pictures. This is their wastewater treatment plant in the foreground here. We're going to look at each of the processes very quickly, but you can see it takes up a huge amount of acreage at the plant. Can we have the next slide? So Ken Norcross, who couldn't join us tonight, is our expert wastewater and water quality engineer. He worked with us very closely on the Mount Air plant. He has 42 years of designing and troubleshooting industrial wastewater plants. More pertinent here, he has consulted on 9 pulp and paper wastewater plants in the United States and Canada. So he knows his way around the wastewater treatment of these kinds of mills. He has 19 patents in water and wastewater. He has his bachelor and master's degree from Vanderbilt University. Next slide. So what I'm going to do is, these are some slides that Ken would normally talk about, but I've worked closely with him. My background is also in wastewater treatment. So where do the odors come from? Well, the odorous chemicals are a byproduct of the pulping and wastewater treatment processes now used at the New-Indy mill, and include hydrogen sulfide, that's H2S. You'll see that abbreviated as we go forward, and methyl mercaptans, which is another toxic set of chemicals that have quite noxious odors. So the odors come from a number of places at the mill. They come from stacks where emissions are going to the atmosphere. They come from vents at various places in the mill. They come from the wastewater process, from sludge that's generated by the wastewater process, from wood chip piles and other locations. So what can be done? The EPA and the state have come in and measured the levels at various locations in the plant and found them to be excessively high. But more importantly, EPA has stated that the technology exists to reduce craft mill odors, such as this mill, by more than 99%. So what has gone wrong? What has caused this big problem? Next slide. So you'll hear about foul condensate. At one time, New-Indy's predecessor, in fact, when they first came, they were collecting 50% of that and putting it through a steam stripper. Well, after they made the conversion to brown paper from white paper and started generating more of these noxious chemical odors, they shut the stripper down and they put all of the foul condensate right into the treatment plant. Well, these chemicals, such as hydrogen sulfide, they want to evaporate out of the water and move away from the plant. And that's why we've had such a problem with odors. So New-Indy was ordered to restart the stripper by DHEC. And they finally did that, although they've had it out of commission a few times to install some parts. It's a very old piece of equipment. But even when they get it up and running properly, it is inadequate, according to our wastewater expert, to handle the volume of hydrogen sulfide and other toxic air pollutants that are generated by the new brown paper process. Next slide, please. So I'm going to quickly show you some photos we have taken, or we have from the plant, to give you an idea of how it looks and how out of repair it seems to be. This is where the foul condensate comes out of the mill and just flows out into an open channel, which is a great way to release all these noxious chemicals to the atmosphere. Ken Norcross, whose career has been in troubleshooting and fixing wastewater issues, says this should be covered and the toxic pollutants collected and scrubbed, which means treated before they're released to the atmosphere. Next slide. Another area of great concern where we have odors is what's called the Aerated Lagoon. You see a photo of that down in the lower left corner. This is a treatment process that provides oxygen and attempts to destroy organic compounds. In this location, when EPA came in and took measurements, they found 7,000 parts per billion this past April. Recognize that you can smell hydrogen sulfide at 1/2 a part per billion. So this is 14,000 times what can be smelled. The solution to that, according to Engineer Norcross, is need to properly size the strippers to prevent the odorous pollutants from even entering this lagoon. You need to dredge out the solids in the bottom, add some aeration, and even consider covering it and scrubbing the gaseous emissions. Next slide. Just to give you an idea and to harken back to what Tommy Pope said, in 2005, we have a historic photo showing how Bowater was properly running these aerobic lagoons. You see on the left, those little mushroom type things are all the aerators stirring up and breaking down the wastewater as they should. On the right, this is that same aerated lagoon jam full of sludge and solids, such that the aerators can't even operate, or many of the aerators can't. So that's the difference between the old Bowater and the New-Indy. Next slide. Another area where odors are coming from are the holding ponds. These are huge. One of them is 32 acres, another's 110 acres. What happens is it comes out of the aerated lagoon to just sit in these ponds, and the sludge settles to the bottom. The odors waft off into the atmosphere. These need to be aerated and not allowed to sit and percolate bad odors to the neighborhood. Next slide. Another area where we believe that, or our expert believes that there's a lot of odors is in the sludge process. The sludge is what, when you treat, is what you wind up taking out of the water before you discharge it. There's so much sludge at this location that New-Indy has put in these massive bags that are shown in this photo here to allow water to drain out and then have the sludge so they can ship it off site. This whole process typically produces odors, and yet they failed to cover it and scrub the area so that the odors just, again, are released to the atmosphere. Next slide. So what else should be done? I guess this is more of a summary. New-Indy needs to at least double the odor stripping capacity. So these noxious chemicals are not going into the wastewater treatment plant. They need to, in other areas where odors are being emitted, cover them and scrub them before releasing innocuous chemicals to the atmosphere. They need to add aeration to lagoons. The wastewater treatment plant here is decades old. The original plant was built in 1957. So been very little done to upgrade this plant and convert it to the new process that New-Indy is embarking upon. And if this can't be done and can't be done completely, the only option is to reduce paper production so that the treatment plant that's there can try to handle what's coming to it. Next slide. I'm going to turn this over to my colleague, Deborah Jennings, who, like me, was with one of the largest law firms in the country and now in the world. She was the head of our environmental law department. If we could see the next slide, Ray. Here's a little background information on Deborah. She was a partner in our firm for 30 years. She worked on the air side of cases primarily. I worked more on the wastewater and groundwater side. She chaired our national environmental defense practice. So again, as Phil mentioned, we're usually working for the large corporations. She specialized in air and she worked with us closely and was very effective in the Mount Air case. So I'm going to turn it over to Deborah to talk a little bit about air.
Thank you, Roger. And next slide, please. As Roger said, although I've done every aspect of environmental law over the years, in the last 10 years, my specialty has been primarily in air. So I have focused in on the air emissions that blanketed the community, particularly during the period right after the conversion. So recall that, as Phil pointed out, between September and November, the plant converted from bleached to brown paper production. Prior to that, more than half of one of its key waste streams, the foul condensate stream, went to a stripper to remove toxic air pollutants. A stripper is a pollutant control device, and it has a very significant purpose, which is once the stream goes through that device, it has removed most of the noxious chemicals. So among those were hydrogen sulfide and methyl mercaptan. And sadly, part of the conversion was to eliminate the use of the stripper. Prior to the conversion, as I said, more than half went through there, and you didn't really have the problem that you saw in spades once the conversion occurred. Now, significantly, at the time, production was such that just 90 gallons per minute of this foul condensate went beyond the stripper and into the outdoor lagoons that Roger has depicted, 90 gallons per minute. Now, would you go to the next slide? After the conversion, as I said, they stopped using the stripper. That was part of the project. And at that point, they increased production, and 720 to 800 gallons per minute went to the outdoor lagoon. That's almost 10 times as much foul condensate, and it is foul condensate from which the hydrogen sulfide and the methyl mercaptans have not been stripped. And what happens when that foul condensate flows into the lagoon? those toxic air pollutants disperse into the air. That's just a natural process. They're very evaporative. They evaporate into the air and they blanket the community. So that is the reason why you had 17,000 odor complaints, as Phil pointed out. And that is the reason why you had very dangerous levels of these dangerous substances in the air that you were breathing. Next slide. Now, I mentioned that two key substances of concern are hydrogen sulfide and methyl mercaptan. On hydrogen sulfide, as it's very, very volatile, and that means that once it hits the lagoon, it evaporates. You can expect it to evaporate into the air. It has a very distinct smell, rotten eggs. If you live in the area, you know what I'm talking about. And it can be smelled at an extremely low level. 0.5, 1/2 of 1 part per billion, human beings start smelling hydrogen sulfide. Methyl mercaptan, similarly, is a dangerous toxic. It's a flammable gas. It has a putrid smell, and you can detect it at levels of 1 part per billion. But I'm not really here to talk to you about odor. You all know about odor. I'm here to talk about danger. Both of these substances can cause serious adverse health effects. Next slide. As Phil mentioned, the EPA issued an emergency order under the Clean Air Act. Now, I practiced environmental law for 30 years, and I specialized in air, and I have very seldom seen EPA, US EPA, go to an emergency order under the Clean Air Act. It's a very rare circumstance, and they only do it when there's clear evidence of an imminent and substantial endangerment to the public health or the environment. So if you look at their papers, you'll see that's what they alleged based on measurements they took of these toxics in the air. Now, unfortunately, while it was ferocious to issue the order, the requirements of the order are not that stringent. They establish some pretty loose levels at the fence line for the plant and some pretty ambiguous obligations for New-Indy. And in our view, it's just not enough. I mean, we're talking about a community that was put at risk, and it is a process that is dangerous in addition to creating odors. And so much more needs to be done. And that's a big part of what we want to do. We want to really make sure that the problem is addressed. Next slide. DHEC also issued an order. They seem to be more oriented to smell. And I might say both of these agencies have continued to work on finding a solution to the problem. They're working with New-Indy, they're receiving New-Indy's input, and they're trying to come up with a solution. But we think that needs to be watchdogged by us and by the community, because you want to have a permanent solution to the problem, not just a quick fix, not just an inexpensive or cost-effective fix. You want to have a permanent solution that is protective of the community. Next slide. Now, I'm working with Dr. Henry Cole, and he's a very experienced environmental and atmospheric scientist specializing in air. Will you go to the next slide? He's an expert, particularly in air pollution meteorology, in air quality modeling, and so on. He was a senior scientist at EPA, and he specialized in modeling, which I'm going to talk more about in just a moment. But as you can see, he's very credentialed. He's received a number of honors, and he's a PhD in this specialty with huge experience over a career. Next slide. Now, what is displayed here is a chart that was in the EPA order, and it summarizes the actual measurements of concentrations that EPA took and upon which they based their emergency order. Now, what's significant here, and the exact numbers don't matter so much as getting a sense of the levels we were seeing, but these levels, as you can see, are in the hundreds of parts per billion. I'm looking at 473. Can you make it just a little larger there? Let's see, 943, 500, 3,000. These are very, very high levels in parts per billion of hydrogen sulfide. And to know how high that is, compare it to what you see on the left in the blue banner. This is the minimal risk level established by the Agency for Toxic Substances and Disease Registry, which is part of the CDC. And what they say is that for hydrogen sulfide, the level you have to be at to not expect health effects is 70 parts per billion. So compare that to the actual measurements that EPA was taking that are ranging up to the hundreds of ppb to the thousands of ppb, compared to the safe level of 70 ppb of hydrogen sulfide. So what that says to us is that there were very significant concentrations of the very dangerous substance, toxic air pollutant, hydrogen sulfide, that were blanketing the community at least from November through April. Next slide. Now in this map, what we have done is take those EPA measurements and plot them on a map. Now, bear in mind that when you have these measurements, what EPA is doing is taking a particular point in time and a particular place and measuring the concentration of hydrogen sulfide at that moment. So it's kind of an instantaneous test that they are doing. And you can see, first of all, that there are very significant numbers going out a very significant distance. The first line that you see, the purple one there, is a 2 miles out. And you can see that 2 miles out, you've got hundreds of ppb being depicted. And those are actual measurements of hydrogen sulfide in the air. But you can go as far out as the red line, which is a 5 mile distance. And you can see the Catawba Nation is outlined in green. And as far as 5 miles out, you have an EPA measurement at 141 parts per billion, twice the level that the CDC tells us is safe. So that suggests to us that while we know for sure that the communities right where those monitoring points are were at risk, we suspect the entire area was at great risk. And how do we figure that out? What can be done is there is an EPA model that's been established, well used, peer reviewed, etc. It's completely qualified to use. And that model is a computer program that allows you to enter the terrain characteristics where you are. You enter the meteorology over the last several years, and then you take the emissions from the plant. And in this case, we also have actual measured emissions, and we will be able to tell you the extent to which that entire area was subjected to emissions and at what levels during this time period. So we're actively working on that modeling exercise, but we already know, based on the measured concentrations, that it's highly likely that we will see great depth and breadth of areas that were blanketed with excessive emissions of hydrogen sulfide. And we have every reason the same could be said for methyl mercaptan. Next slide. Now, another member of our team who I'm pleased to introduce, he could not be here, is Dr. William Meggs. Dr. Meggs is a professor at East Carolina University, and he's one of the leading experts in the nation on the topic of the toxicology of hydrogen sulfide. He is both a medical doctor and a toxicologist, and very widely experienced in the impacts of these toxic air pollutants on human beings. So you can see he has multiple board certifications. He's a professor at East Carolina and both a medical doctor and a toxicologist. Next slide. So what he has done is to provide a thumbnail sketch of the kinds of human reactions you can expect from excessive exposure to hydrogen sulfide. And you can see on the left side, there's a category of respiratory effects, irritation of mucous membranes, red eyes, burning, nasal problems, sinus problems, asthma, induction, shortness of breath, and wheezing. On the right side, neurological problems, headaches, memory, difficulty with concentration, permanent brain damage, clumsiness, staggering, anxiety, depression, all very serious repercussions from breathing air that is riddled with toxic air pollutants like hydrogen sulfide. Next slide. Finally, I want to point out that he gives special attention to vulnerable populations because they are the most at risk. And that would include people with respiratory illness like allergies, asthma, COPD, people who have pre-existing neurological and psychiatric illnesses, a history of migraine, headaches, children, and the elderly. So these are very serious substances. Those are only the effects of hydrogen sulfide. We also have methylmercaptan that was blanketing the community. So we have every reason to believe that as we investigate this case and look at it in more depth, and particularly when we know which areas suffer the heaviest concentrations of these substances, that we will find that people have suffered with these kinds of illnesses from breathing the air. So now I'd like to turn it over to Phil Federico. Turn out, your mute is on.
I do that all the time. Thank you, Deborah. So as you can see, Chase Brockstedt, who's my co-counsel, was going to address this part of our presentation, but he is busy this evening. And so I'm going to pinch hit for him, and we're going to talk about damages. And damages are really the effect, and in this case, the damages are really health effects that we're most concerned about. So if we could go to the next slide. Talk a little bit about Chase, my co-counsel, before I get into damages. Chase and I worked together on this Mount Air case that I told you about. Chase is a founding partner with the law firm of Baird Mandalas Brockstedt in Delaware. He and I first worked together about 10 years ago in a class action case known as the Bradley case, which settled for $123.5 million. That's how we met. And we've been working together ever since. And let's go to the next slide. So you've heard us talk a little bit about DHEC and the EPA and what they're doing, and we're very fortunate that they are involved. But as Deborah and Roger alluded to, they only can do so much, or only willing to do so much, and we see this repeatedly. If Delaware's version of DHEC, which is called DENREC, and if the EPA had done what they were supposed to do in Delaware, we wouldn't have had the Mount Air case to pursue, and they wouldn't have voluntarily paid $205 million for what they did wrong. And it's pretty typical. The state and federal agencies are typically overworked, understaffed, and underfunded. And the permits that they issue, and this is a perfect example. We have a case where they've been letting these people go for 7 years without an updated permit. They let them convert from bleach paper to brown paper without a permit. I mean, they really permitted this problem to happen. And so that's why we're jumping in. We want to make it right. So private litigation, really what it'll do is it'll help compensate you all for your personal injuries, for your reduced property values and damage to your property, and for what's called remediation. And remediation, I think, is probably the most important. Remediation's fixing the problem. We want to try to get a temporary fix as quickly as we can, so as to somehow mediate what's going on now and get a permanent solution which will last forever. We know how to solve the problem, and we just need to work through the litigation process as quickly as we can to bring about a solution. So the team you have brings extensive experience and expertise. If we could go to the next slide and talk a little bit about why you should hire us. You know, and we hate to brag on ourselves, and we let our results speak for us. But let me tell you what you're really getting. You're getting 4 different law firms, and literally dozens of lawyers collectively that work on this team with enormous experience. We put out our own money, okay, to pursue this case. The expenses that we incur in the Mount Air case, we spent over $4 million of our money to make it right, to fix the problem. We have 20 experts in environmental engineering, various healthcare fields, air pollution, wastewater pollution, diminution. We have property experts, economists, and the like. If we could go to the next slide. So talking about the experience, just a little contrast between this case and Mount Air. In both cases, there were out-of-town companies. You know, New-Indy, we believe, stands for New England, which is where Robert Kraft was from. And Indy is for Indianapolis, where the Schwartz partners are from. They're out of town. They come in. It's no problem for them to create an environmental disaster in your backyard because they don't live there. And in the Mount Air case, we had an Arkansas company do that in Delaware. In both cases, both companies increased production dramatically to increase profits dramatically at the expense of the environment. In both cases, environmental compliance was ignored. In both cases, air pollution, specifically hydrogen sulfide pollution and groundwater contamination are present. And I would point out that of the $205 million settlement from Mount Air, 140 of that actually went to remediate the problem, overhaul the plant, and permanently correct the pollution. Because you can do this. We don't want to run these people out of town. We want this mill up and running. We want people to go to work. But by the same token, you can do it and do it safely and be a good, responsible corporate neighbor and in environmental compliance. But it's going to cost you a little bit more and cut into your profits a little bit. But we certainly think they've profited enough over the years. So no Band-Aids here. We're looking for a permanent solution. If we could go to the next slide. So what do we intend to accomplish here? Well, one of the things that we are looking at is pursuing what's called injunctive relief and asking the court to help us with some remedial measures, because a long-term solution in terms of remediation and fixing the problem, overhauling the plant. I mean, this is not something that you can turn around in a matter of a couple months. It's going to take a couple years, frankly, to rehaul the plant, no matter how much cooperation you get and how much money you're willing to throw at it. It just takes time to get all that work done. So we're going to focus on some interim injunctive relief and try to, and that may involve a decrease in production short term. But ultimately, our goal is a long-term solution. We're going to work with DHEC. I've already spoken to the head of DHEC personally about this case, and we plan to meet in a couple weeks. And we'll get their cooperation and they'll get ours because we have the same goal in mind. And I have already reached out to the attorney who represents New-Indy. And I've been talking to him about how we can do this quickly and amicably. You know, there's an easy way to do this and a hard way to do it. We'll get it done and we'll just see how they want to do it. So, and certainly most importantly, it's about, you know, it's all about you. Frankly, you as people who have been put in this situation, the injuries you all have sustained, the damage to your property, the inconvenience of the like, we certainly want to make it right for you all as well. So let's go to the next slide. So why sign up now? Well, I got to tell you, there's nothing that speaks louder in cases like this. And one of our experts, Dr. Dahlgren, was involved in the Aaron Brockovich case. And I was talking to James one night and I said, you know, that was a real landmark case in environmental law. And why do you think it was such a landmark case? And he said, the people came out, the people spoke. And that's really what this is about. As Mr. Truitt said to you all, he's never seen an air case, and I know Deborah has never seen an air case where the quality of the air was so bad and the amount of people affected was so significant as this one. And we really need the people to come out in numbers, to sign up and to work as one to bring this to a head. The court will respect this case much more depending on the number of people we have. If we have, a couple hundred, that's one thing. If we have a couple thousand, that speaks much louder. The court's going to feel greater responsibility to move more quickly and to provide us with a better solution. And so will DHEC. DHEC's going to respond more favorably the more people we have signed up and involved in the case. And I tell you, New-Indy, ultimately, the thing they fear are the masses. And they know that a jury in Rock Hill will respond, especially if we have a large number of people who are behind this effort. So we want to put a permanent end to this problem, and we can only do it with your help. So I really would encourage you all to document every time you smell a smell. Keep a diary. If you have any symptoms, document those as well. I would encourage you, if you have any symptoms, to see your physician about them so they get documented and so you can get some medical advice. And I would encourage you to talk to your friends, families, and neighbors about signing up for this case and letting us represent you. We have a website out there. We have a phone number out there, and we're easy to get to. So if we could go to the next slide. And before I talk a little bit about the class action approach, Ray is our moderator. Ray, I don't know if we can at some point get the phone number and website up on this.
Yes, that'll appear once we begin the Q&A.
Thank you. Okay, so briefly, a class action approach is really based on expert determination. What is going to happen is that our experts are going to come in, they're going to look at all the data, all the monitoring, and they're going to try to map out an area that has been affected to a significant degree such that it's likely to have caused either personal injury, property damage, or both. Now, the benefit of a class action, as I said before, is strength in numbers. The greater the exposure to New-Indy, and what I mean by that is the greater the amount that they may ultimately be responsible for, the more leverage we have. The other thing that's very helpful with a class action is if any of you individually wanted to bring this case, to bring the case would cost millions of dollars, $2, $3, $4, $5 million, and it would make it economically not feasible to pursue for a lawyer or for any individual. But when you can spread those costs over hundreds or thousands of people, and the lawyers will advance the cost for you, it makes it obviously attainable. So the steps are to investigate, to assemble an expert team, which we've done, and our team's growing, do an initial investigation, which we did for 3 or 4 months, file our lawsuit, which we've done, and now we're going to start what is called the discovery phase, where we are going to request documents, we're going to take depositions, and we're going to find out all the information that's possible. We likely will go to mediation at some point, I would think. And if we cannot get this case voluntarily resolved, we'll have a trial. We will be picking some class representatives. We have one in particular who we utilized with which to file our complaint, but we likely will pick some more for purposes of discovery. One of the things that's a high priority for us is client communication, and we send out frequent status letters, and there is a website and a phone number, and we always respond, if not immediately, within hours, to any questions any clients may have. Our fee is based on a contingency. We only get paid if we win. The court will ultimately decide how much of a legal fee we will get. You'll see a number on the contract. I can't frankly remember what it is. It's typically around a third or 35% or something like that. But in cases like this, the court usually awards somewhere in the neighborhood of 25% to put more money in the pockets of the victims. And as I said, I talked about cost already, so we can go to the next slide. And Tommy, this is the Q&A, so I'll let you pick that up here.
Sounds good. I appreciate you guys hanging on. There's so much information we want to share that we've tried to thin it down, but I know we're probably going over the time we intended as presenters to get out to you. So we want to get in the Q&A. One thing I would point out there, as far as client contact, there are a number of groups that you guys had already formed, and particularly in Rock Hill with Elrod Pope, we've had several meetings. I believe productive meetings with the folks that lead these Facebook groups, and I know some of them may be tuned in tonight, but we want to work alongside what they're doing, and we don't want to commandeer anything they're doing. And I think you guys are doing a good job, because I think the core of what Phil said is the community rising up, the community coming together, and so we want to speak with one voice in that regard. With that being said, I'm going to turn it over to Ray. We can, I'll point out, and he may want to elaborate further. There's a Q&A section at the bottom. You can type in your questions. We will get to as many as you can. Again, knowing your time's valuable, we will work with you as long as you want to hear some answers. After that, I'll be back with you to wrap it up. Thank you, Ray.
Sure thing. Yes, we will try to answer as many questions as possible. And if we're not able to answer your question, we have a list here with your name, and we will be sure to follow up with you after the webinar concludes. First, we've received a couple questions regarding the Mount Air case. Phil, if you're able to answer these. First, one asking where it was and where the Mount Air case was. Perhaps you can elaborate a bit on the case generally. And second, the fact that it settled for $205 million, did the company ultimately fix the problem, and what does that timeline look like?
Sure, and they are good questions. Just a little background on the case. Mount Air is a chicken processing company, excuse me, out of Little Rock, Arkansas, and they bought a plant in Millsboro, Delaware, in the year 2000. They ran that plant in violation of their permit for 17 years. And after 17 years, the plant literally failed. As you can sense from this particular case, the New-Indy case, what happens is these solids actually start choking off the process of getting rid of the pollution. And when that happens, where does the pollution go? It goes into the air and into the water. And that's what happened in Mount Air. Finally, in 2017, the plant failed. It became a very high profile situation. That's when we got involved. The $205 million settlement, as I said, 140 went to remediation. There is a remediation plan that's been approved. The remediation plan is in progress to temporarily help the individuals. They have ceased releasing any hydrogen sulfide. That part of the plant was essentially decommissioned or otherwise. We were able to stop that problem pretty much immediately. With regard to the groundwater pollution, which takes longer to deal with, we immediately got everybody water treatment devices for their home. And so now the water they're drinking is purified, and they no longer have that problem. Once the full overhaul of the plant occurs, which will occur in a matter of a number of years, they will no longer need the water treatment systems in their houses. So at this point, you know, we have not had any complaints of foul-smelling odors since the case is settled, and everybody's drinking clean water. And once they complete this remediation plan, which cost $140 million, not only will the plant be up and running, but it's going to be up and running to the point where if they want to double their production, they'll be able to do it and still not have a problem. So we built in increased production for the future, and I hope that answers your question.
Thank you, Phil. Before we move on to the next question, Phil and Tommy, now that we have the phone number and website here up on the screen, if you could just take a moment to underscore the importance of calling that number or visiting that site, and why we'd encourage people on this webinar to do so.
So I noticed one person had actually said something about, well, what about the computer savvy, the people that aren't computer savvy? And this has been interesting. The two things: one, what logging into the site and then or giving us a call and giving us a call back obviously gets you signed up. but it also helps us share more individual information. One of the things we've run into, and again, we've had several good citizens in the community that that have my mobile number and contact me about how can we help, how can we get the message out. The biggest difficulty we've had is we need people to spread the gospel, so to speak, to spread the word of what they've heard, what they knew, and get people to join in. So, Ray, I think, obviously it's important. We have been diligent in working to follow back up with people. Unfortunately, I always see one that says, I didn't hear back. I think some of the folks in Delaware are helping return the calls. Some of the folks in Maryland are helping return the calls. Some of the folks at Elrod Pope are helping return the calls. So like most of us, if you see a strange number, you don't answer it. It may very well be us calling back. But if you have a problem with that, don't hesitate to contact us again. We'll make sure we get on top of it, that you're included.
And let me just follow up, Tommy, if I may, just so you all understand, we can't represent you unless you sign the agreement of retainer. Just calling us on the phone and us sending you a letter and an agreement of retainer, we don't represent you until we get that signed agreement of retainer back. And there are currently over 300 agreements of retainer that we've sent out that have yet to be returned. And we know how slow the mail is these days. We certainly understand. But I would encourage you all, we can't close the loop on your participation until you get that agreement of retainer back to us signed. So just wanted to put that friendly reminder out there.
Thank you. Moving to the next question. Do we know if DHEC and the governor have done anything with the increase request?
We do not know. And certainly, and it's interesting because I draw again on the similarities between this case and the Mount Air case. In the Mount Air case, there was a great deal of communication between Mount Air, the corporation, the governor's office, and what is called DENREC up there. And for years, they had been sort of colluding with each other to keep that plant going and really let them get away with violating their permits. And I'm not saying that that's happening here. I'm saying we don't know. We don't know the level to which there's been any communication, and if there has, what the communication has been about. But we will, now that we filed our lawsuit, we will be able to do discovery where we will request documents, emails, memoranda, etc., from DHEC, likely from the governor's office and maybe the office of other politicians who might be involved, and certainly from New-Indy, to see what has been going on behind the scenes. We're entitled to all that information. We will get all that information. And certainly as this case progresses, we will continue to update you and share that information with you all as we do these periodic town halls. So the answer is right now we don't know, but my guess is we're going to find out sooner probably as opposed to later, and certainly share that information when it becomes available.
Next question, do we know if any of the pollutants seep into the groundwater?
Roger, that's probably a good question for you to talk about.
Right. I see there's several that are along that line. Is it safe to drink the water? We're at the early phase here of delving into that. We have outstanding FOIA requests with both EPA and DHEC that relate to some of the issues at the mill that could contaminate groundwater. An old mill like this, it's very common that there have been leaks in lagoons over the years. And then there's the question about if it's in the groundwater under the mill, where does it go? In general, it probably goes to the water, but we have groundwater experts who are waiting until we can get a little more information on what contaminants may be under the mill. And we'll be looking at that. So I don't think at this point we're saying that anyone's well is contaminated or not. We just are not quite that far along, but we hope to be able to answer that question soon.
And Roger, could you talk a little bit about in Delaware, we had people do or get their wells tested. Could you talk a little bit about that?
Yes. Oftentimes the state or the county health department will perform some limited testing. for certain contaminants, or we'll refer you to a private lab that can do that for a fee, which may or may not, usually is not that expensive. What we're trying to do, though, is focus in on what are the contaminants that are there, so that when you do test, we're looking for the right things, because there can literally be hundreds of different chemicals that could be in the groundwater at relatively low levels that are still harmful if you drink them.
And Roger, at this stage, do we have even a few contaminants that we're looking at based on the preliminary information we've gotten from our experts?
Yeah, I think we're looking at certain chemicals that New-Indy admits that they are using at the facility, and so if they're using them there, there is some likelihood that some of them are winding up in the groundwater. That's very common with large industrial complexes of this age and vintage.
And I would mention that as soon as we get a list of specific contaminants that our experts think are worthy of testing for, we'll disseminate that information to everybody, so that if any of you do want to get your wells tested, you'll know exactly what contaminants to test for.
Next question, it's actually two different questions here that I'll combine into one. They're on related issues. First, has an injunction been filed to stop them while this lawsuit is in place? And second, can the case be made for complete shutdown given the numerous violations, or at least stop them from continuing to produce brown cardboard?
Yeah. Well, first of all, in our lawsuit, we request there's injunctive relief. So it was in the lawsuit we filed. Before we can actually get that issue in front of the court, they do have an opportunity to file an answer, and we'll have an initial conference with our judge. As to the injunctive relief we can seek, we certainly can ask for a total shutdown. That's pretty much unprecedented. And the reason I don't think it would be successful here is I really think if they went to half production, the problem would stop. And so I don't even think our experts could or would, or even should testify that a total shutdown is necessary to temporarily solve the problem. But certainly going to 50% capacity, I think probably makes more sense in terms of injunctive relief. But again, it is the fact that they have so many violations, while it's helpful, is not necessarily determinative of whether or not the judge will shut the plant down. So it's a little difficult to predict what the judge will do when we get to the point where we're asking for that specific relief. And it's difficult to predict how quickly the judge will entertain our request in that regard, but we're going to push as quickly and as hard as we can on it.
A few questions have come in regarding the water and whether it's safe to drink or not. Roger, can you elaborate on your prior response and what you would recommend to residents in the area?
Yeah, I mean, I think it's always good to filter your water if you're on a well, and try to take out what contaminants you can. Specific water treatment systems can be fairly expensive, not only to purchase, but to maintain. And they're generally focused on certain contaminants. In our Delaware case, it was nitrates. And so there's specific treatment devices that address that, but don't address other chemicals. So I think it's always good to drink bottled water or filtered water through some kind of carbon filter. That doesn't necessarily mean it's absolutely safe. But as Phil said, as soon as we can get our arms around what contaminants are or could be in the groundwater, we'll try to address that in detail.
Thank you, Roger. We've also received a couple questions regarding monitoring. Is there any way or is there any current monitoring in real time, providing data on the pollutants that may be in the air?
Well, let me talk a little generally about that, and then I want to turn it back to Roger because he was just telling me about the most recent monitoring that's about to be installed. It's important to recognize that they did this conversion and then blanketed the community with the emissions that resulted from piping all of the foul condensate to the lagoons. Upon the issuance of that order, they were made to reroute a big part of that foul condensate, about half of it, back to the stripper. So that immediately reduced some of the hazardous air pollutants. And then they have essentially, and here I don't want to go beyond my own expertise because I'm really just a lawyer, but they have essentially put some additives into the basins in order to curb the emissions temporarily. So they have a quick fix happening right now, and there will be some monitoring to make sure the quick fix is working. But that's not a permanent solution. However, I do think you can take some comfort from the fact that the agencies have made them take some measures to have a significant immediate impact. But the big question mark is going to be what they do over the longer term. So Roger, will you talk about the monitors that you mentioned?
Right. One more comment on the groundwater, and this is not absolute, but in general, if you are located at a higher elevation than New-Indy, and of course New-Indy is down near the river, in general, groundwater flows from high areas to low areas. And so in that situation, if you're 100 feet above the elevation of the river or of New-Indy, it's pretty unlikely that you would be impacted by them. Now, on the other hand, if they are discharging contaminants into the river, millions of gallons per day, and there is an intake that takes that water in and doesn't fully treat it, that can be a different issue. Now, we understand there are some intakes upstream of New-Indy, and there's one downstream, but it's quite a ways. We, again, haven't gotten into the detail yet of fully understanding whether they have an impact on that downstream intake, but we will look into that. On Deborah's point, what's been occurring, there have been 10 different monitoring stations that EPA set up but removed at the end of last month. And we understand there are 5 additional ones that New-Indy has been ordered to install. One of our concerns is that these are all focused on hydrogen sulfide, which, as it turns out, is much easier and cheaper to monitor than you heard about methyl mercaptan. There's perhaps other toxic air pollutants that are being emitted by the plant. So we may not have the full picture just looking only at hydrogen sulfide. And it's curious that DHEC and EPA have not required them to monitor for these other toxic chemicals. But actually, there is some monitoring that's occurring. That's good.
Mm-hmm. I was going to say they did order them to test for it, but they said that New-Indy said they couldn't find anyone capable of doing a test for the mercaptans. So I think
can we find somebody for them?
Sure.
Well, we actually have some monitoring experts that have explained to us how that can be done, and it can be done, and it is more expensive, but it certainly would be interesting to see what the concentrations are of these other chemicals that we believe coming off the mill.
I think it's important to remember, though, that the short-term things that they are doing are not a fix. I mean, you can see from the various photos here that the aeration is not being done properly, and therefore you're going to have emissions going forward. There's a huge backlog in sludge, and you're going to have emissions from it going forward. So these short-term fixes are just to kind of put out the fire and stop the ongoing danger, immediate danger to the community. And what the monitoring does, it doesn't tell us that everything's fine. It tells us The short-term fixes are holding the status quo while a much more permanent fix is developed. And that's where we want to make sure that it is truly permanent and it is truly thorough, and you won't have a recurrence of these problems.
Well said, Deborah. You know, what they're doing now is like putting a Band-Aid on a gunshot wound. So we intend to fix the problem.
Next question, someone has asked how they should best document and submit medical issues they are experiencing.
Well, I think the most effective way to do that and the most appropriate way to do that is to consult with their physician. You know, a lot of us don't like to go to the doctor, you know, and a lot of us, if we have symptoms, normally don't think much of it. And it's not until things get pretty bad that we'll reach out to our healthcare provider. This is a situation, frankly, where symptoms that don't sound particularly serious or are not particularly worrisome under normal circumstances are associated with a toxin that can cause more serious and long-term damage. So, you know, when we go to prove our case, it's helpful to have a diary from the client, but at times could be viewed a little bit as self-serving. But if we have medical records documenting complaints, it's very, very helpful. So I would encourage people to see their healthcare provider.
I also, to add, Phil, I saw one of the folks had asked about actually articulating the concerns regarding New-Indy when they talk to the doctor. And I will share this. It is always important not to be a complainer, but to accurately report what's going on, when you believe it's going on, and if you believe it's correlated to the odors of the smells or you moving here, to articulate that to the doctor. Reason being, as Phil said at the end, the doctor's report, the doctor's records are kind of the gospel you use in a case versus you can say, well, I told the doctor so-and-so, but if it's not in the records, for the most part, it didn't happen. So when you do go see your physician, again, share as much information or any correlation you see with what you're experiencing at home to make sure they document that properly.
And the other thing I would mention, Tommy, and I agree with you 100%, call DHEC. Yeah, I mean, every time you smell it, you may not want to get on the phone and make that call and make that complaint, or get on the computer and make the complaint. But, you know, if you want to help us help you, that's certainly something you can do, because the more complaints they get, the stronger our case is.
Phil, Tommy, the next question is regarding how many residents have joined the class action lawsuit to date.
Tommy, I think we had a meeting earlier today, and correct me if I'm wrong, but I think we have over 300 people who have signed agreements of retainer that we have back. Is that about accurate?
I think that's right. And again, that amount out, you know, that have not been returned. And, you know, we talked about focusing on that today, but, you know, the irony we're running into is when we saw the numbers that are calling to complain to DHEC, what we really need is people to step up so we can have those same type numbers when we go to the judge, when you ask about an injunction, when you ask about various legal things, as Phil led off earlier, we need their attention, and the more people we're representing when we stand there, the more attention we're going to get from New-Indy and from the Corps.
Good point.
Next question, is there any evidence that New-Indy knows the risks associated with this?
Well, they have a responsibility to know the risk associated with this. If you're going to run a company and you're going to put out toxic pollutants out of your mill and disperse them into the environment, when you know that there are people that live within breathing distance of your mill, you got to know what you're releasing. And they do know, and the permit requires them to know, and the permit requires them to monitor, and they violated the permit. So of course they knew. Now I will tell you, the depth to which they knew and the length to which they went to ignore the problem, we'll know more about as we get documents and as we take depositions. But if they are running this plant in a prudent fashion, in a non-negligent fashion, when they do the conversion, they need to hire an environmental consultant to say, we want to do this conversion. What impact is it going to have on our emissions, both water and air? And then they would have gotten a report from an environmental consultant, and the report would have told them what problems were in store for them and how to prevent them and what they needed to do. They didn't need to be decommissioning a stripper. They needed to hire 2 or 3 more and build them and put them in a position where they could handle the foul condensate. So to answer the question, we believe that they knew what was happening. The extent to which they knew it and the extent to which they ignored it will become more obvious as we do our discovery.
Thank you, Phil. This next question is for Tommy. What can the area political representatives do to put pressure on New-Indy?
I'll back up just a tad because I knew some of the questions were asking what has already occurred. And so Senator Johnson from over in Fort Mill, Lancaster, had a proviso in the budget. And I'm going to try to give you a quick version. A proviso is a 1-year law if it passes in the budget. So many times things get attached on the budget that will really be better tackled in full legislative process. But in particular, he was putting a freeze on the expansion. It was told that when they came together with the conference committee, the House and the Senate each have 3 members. The 2 of the members from the House, who were 1 a member of Ways and Means, 2 the chair of Ways and Means, both ended up having some relationship with New-Indy from an attorney-client standpoint, and so they abstained from voting on that part of the proviso, so that proviso was removed. I've shared with the groups we talked to before, I don't think there was anything nefarious that was really done. That was Representative Smith, who's the chairman of Ways and Means, Bruce Bannister, who was involved. I think actually his law firm is involved in the citizen group that New-Indy is putting on. So anyway, I'm sure New-Indy was pleased, but I don't think there was anything in that regard. I think we will see when we return to session in January, some work to, and again, it's difficult. If New-Indy would do all the things that you heard could do to remediate, then the legislature doesn't need to step in. But I think you'll see a renewed interest in trying to do some of the things that the legislature can do. Again, I try to strike a balance wearing my legal hat and my legislature hat to make sure ethically I'm hitting that balance. In other words, I don't go to Columbia just do things that make my law practice better. Vice versa, I don't want to help the people that hurt the people that live here by not getting to work on it. So I anticipate again that we will take a hard look in January. The difficulty, I think, is some of the stuff that came from the Senate was the House was never informed of before it was in there, and so we weren't able to work it through.
Thank you, Tommy. I'm going to send this next question your way as well. The person who asked this question said that they hear from a lot of people in the area who, say they have faith in DHEC, and in particular, as soon as you say New-Indy, they immediately say Bowater, which you addressed in
Right.
passing at the top of the webinar. How do we overcome that thinking that New-Indy is not Bowater?
Well, and again, I think 2 things. The first thing is the same thing that Phil had kind of touched on with DHEC. I've dealt with DHEC a number of years, and I think they're more than willing to work toward the problem. They just don't always have the resources. I will say that we reached out and talked to DHEC's attorneys early on in this process, and I envision us walking the same path with them. Going back to the Bowaters thing, again, if I say it, this isn't your daddy's Bowaters anymore, these guys are going to laugh me out of the room. But the most shocking thing to me when I sat down as a citizen and a community member, an attorney, and was talking to all these experts, if you look at the picture that you got on the screen, and then you look at the old picture that Roger showed us of how it was in the Bowaters day, to me, as a layperson, that answers that question. They have chosen, for whatever reason, to let that process corrupt and not fix and hope they'll get by with it because it costs money to clean it out. I was thinking, I know, the size of that thing, but I also know I see front end loaders driving every day, digging holes and building houses and everything. If they wanted to shut down, clean that pond out and do it right, they could do it too. And so, it's been tough. I grew up in Leslie, everybody, we do work at one of the 3 mills. I've got friends that work there. That's why, again, it's about remediation, not about putting people out of jobs. But at the end of the day, New-Indy needs to step up. They can make a fair profit as a corporate citizen in our community, but clean the place up. And if you get the guys that worked at Bowaters in the old days, they'll tell you. But again, picture's worth 1,000 words. The picture that Roger shows us side by side, I mean, quite candidly, the old Bowaters pond looks like a swimming pool, and this looks like a swamp.
Thank you, Tommy. Next question here. My husband signed us up. My question is, do I need to sign up also, or does the retainer cover the entire family?
That's an excellent question. No, we do need a specific agreement of retainer for each individual, and sometimes that gets a little bit confusing. Certainly, parents can sign up on behalf of their children, and we can fashion an agreement of retainer. If you have more than one child, just one agreement of retainer can cover multiple children, as long as we have a parent signature. But everybody 18 and above must sign a separate agreement and retainer for themselves.
Again, I think it's important. You can say why, if mom's in it or dad's in it. I mean, quite candidly, I don't know how to be any more straightforward than this. The strength in numbers. If you've got 5, adults in your household that you can sign up, then 5 obviously takes our number better than 1 when we're, again, dealing with the court or dealing with New-Indy. I think New-Indy is hoping that this kind of fizzles out on the legal end, and they can, as I think as Phil said earlier, take the Band-Aid approach. Again, I keep harkening back this picture. We don't need a Band-Aid. We need surgery out there. And I think it's going to take every one of us that live in this community, that want to stay in this community, to step up and not only call your friends from church, call your friends from the Bridge Club, get family members, get cousins, get whoever you can to sign up, to give us the leverage, to give us the bigger stick going into this battle.
Thank you. We're going to try to take a couple more questions here. Want to be respectful of everyone's time, but I just want to reassure everyone who did ask a question that if we're not able to answer it on this webinar, we will follow up with you after. We have your email address, so we'll make sure we get back to you with an answer. This next question is, what happens if New-Indy were to file for bankruptcy?
That is a great question, and a very practical question, and a question that that we pay very much attention to. It's not our job nor our desire to drive New-Indy into bankruptcy. That doesn't benefit the people who work at the mill, and it doesn't benefit the people who are our clients in this litigation. We were faced with a similar issue in the Mount Air case, where we subpoenaed all the financial records of Mount Air and had them submitted to forensic accountants and forensic economists to figure out how much money, cash flow wise, could Mount Air pay us and us not put them into bankruptcy. It's what's called the financial choke point. So we are going to be requesting that financial information. We're going to get it. We're going to have it analyzed, and we will know how far we can push them. I believe, frankly, that given the combined resources of the Kraft Company and the Schwartz partners that make up New-Indy, that their assets are more than enough to resolve this case and provide proper remediation to all those affected.
Next question. Do we know if DHEC and EPA actually allow New-Indy to convert without a permit, or did New-Indy disregard the permit process and just convert?
Roger, you want to take that one, or Deborah?
Yeah, I'll tell you what we know so far, and we're still peeling back this onion by looking at requested documents from DHEC and EPA, which we have been slow to come to us so far. But what we do know is that they made some submissions to DHEC primarily. EPA sits here mostly in an oversight role. So DHEC is the one who is monitoring the wastewater discharges and the air emissions. They submitted some documents and proposed what they thought the changes would be. I think it's fair to say that they underestimated what the actual emissions and discharges would be based on this conversion. So they may have submitted some documents and gotten some approvals, although they didn't get all the approvals, as my earlier slide indicated on the wastewater when DHEC inspected. But I think, the devil's in the details. What did they tell the agencies they were going to do? What did they tell them the emissions were? And what did the agencies think about that? And we don't have our hands on those specific documents just yet.
I would just add that the extent to which they need approval, generally speaking, depends on whether they're going to be increasing pollutants. And when they make submissions to the agency, they represent what the impact will be of the changes that they're proposing. And in this case, we have drawn the inference, because it's obvious, they never told DHEC that they were going to have hydrogen sulfide emissions in the neighborhood that resulted in concentrations in hundreds of ppb hydrogen sulfide. They cannot possibly have told the agency that. So some time ago, several weeks ago, we requested copies of what they submitted to the agency, and we'll be very interested to see what they told the agencies would happen, but it cannot be what actually happened. So we're going to be on that like a glove. And it may give us a lot more information about whether the agency should have known. But I think the answer is going to turn out to be that the agency wasn't told, or that they were told that the emissions would be way less than they turned out to be.
We have time for 2 more questions. And again, for anyone who has asked a question that we did not get to, we will be sure to get back to after the webinar with an answer. This next question is regarding remediation. Remediation was mentioned with regard to fixing the problem. What about environmental remediation, fixing the damage done to the environment?
Well, that's a great question. And to be honest with you, it's probably a little beyond my expertise. The hydrogen sulfide that's out there, you really can't bring it back. I know that much. Now, unlike groundwater, if we have contaminants in the groundwater, it is possible to take that groundwater out of the ground, pump it out, pump it into a water treatment facility, and then put it back into the ground. That's called pump and treat. As far as I know, the same sort of process is not available with air emissions. So I really, certainly where the air is concerned, I don't think there's anything that can be done. And if there is a groundwater problem, there is the ability to fix it.
Well, on the air side, it depends on how broadly you define remediate. But certainly if it includes removing all that sludge, and installing much better systems, then remediation would embrace a prospective fix on air emissions by removing the source.
The last question.
Ray, let me just jump in and to give you an idea, if everybody were to just look at this picture, see to the right side of the picture where all this, it looks like it's filled in, it's brown, and those aerators aren't really working or not working very well. and see to the far left where it looks clear and the aerator, one aerator looks like it's really, the whole lagoon ought to be like what's going on the left. And if we get remediation, we can make this whole lagoon look like that again, like it was when it was bow water. You know, and this is just one of the areas where the hydrogen sulfide's coming from, as was explained previously. So as Deborah correctly pointed out, we can fix the problem moving forward for the emissions that are already out there in the environment. Unfortunately, not so much.
Our final question, can you all discuss what the next steps are with the court and how that intersects with the importance of people returning their retainer agreements to you and presenting that to the court?
Bill, if you could touch on the court, and then I'd like to wrap up with the kind of pitch of what I think people need to do, if that works for you.
Absolutely. Yeah, the defendants have asked for a brief extension of time to file their answer to the complaint, and they will likely file motions to dismiss, which is pretty much standard protocol under these circumstances. And we will file responses to that, and we will get in front of our judge. You know, I would hope that we're in front of our judge within the next 30 to 60 days to put together some sort of schedule for moving forward. So I really think it's at that point in time that we'll have a much better idea in terms of how quickly the judge is going to let us move forward and try to pursue some interim remediation. And I really think that it's a little bit difficult to be any more precise than that.
So Ray, kind of wrap it up. And I noticed there are a lot of specific questions. Again, as Ray said, we will touch base back on everyone. I don't want, look, we've got almost as many questions left as participants now. So I think we would lose some folks if we try to go. Let me say this. One of the folks talked about treetops and Carolina lakes and how many homes are there and the value of homes. And we need people to join up, to tell their neighbors. I said this before, but some people said, well, why aren't we going door to door? Ethically in South Carolina, I know you laugh when I say lawyer and ethics, but ethically in South Carolina, there's a lot of things we can't do. Now, it doesn't mean you can't do them. Doesn't mean you can't go tell everybody what you heard tonight. Doesn't mean you can't share the information we provide to you at one of these meetings. But ethically, there's a lot of things we can't do. Within those bounds, we're doing everything we can to get the message out. As far as signing up itself, early on, if you remember the last town hall, Phil, that the question became about the medical forms, and there were some concerns with that. You don't need to execute a medical form right now. Later on, if you have a medical claim, you will need to execute that. But right now, the big thing is the contract. And so moving forward, and the other thing I saw in the contract, we're never going to come back and ask you to pay us money if things don't work out. You know, I think that was a concern in the way the language was written. We cover the cost. And then we get reimbursed from being successful. And so we'll continue to work. What anybody out there that listens that wants to do, the best thing you can do is 1, sign up yourself, 2, sign up your family members, 3, sign up your neighborhood. We're going to keep pounding and try to get out there. But we need the volume of people to help us make a difference for all of us.
And I tell you, when we're in court and Tommy and I will be in front of this judge, the first thing she's going to want to know, and it's like this in every mass tort, in every environmental case, how many clients do you represent? And there's a reason that's always the first question they ask us, because that forms the foundation for what happens after that. And if we can go in there and tell her, you know, we have 1,000, 1,500, 2,000, 3,000, whatever it is, the higher the number, the more credibility we have, the more respect we'll get, the better things will go for the group as a whole.
And I know my law firm's going to cringe when I say this, but we're going to get back to every one of you. If something happens and you have not heard back, don't hesitate to call us. We're right here in town. and we'll get an answer to it. Again, I think I just heard 3 employees run out the back door at Elrod, but we'll get on top of it for you. Folks, I want to thank everybody tonight for participating. We look forward to representing you. We're going to keep working this thing together and get the answer. So thank you for all our experts and the team for participating tonight. I'm excited for what we're going to be able to do for our community.
Good night, everybody.
Good night.